Hello everyone, I'm Rong, a Chinese lawyer. Today, I want to talk about the limitation period for claims filed by carriers due to the extended use of shipping containers. Firstly, let me introduce a real case. In January 2010, a Chinese company named Chanlian entrusted a shipping company named Maersk to ship 5 containers of goods from China to India. On February 23rd, the goods arrived at the port of destination in India, but no one had ever come to pick up the goods. The free use period for containers loaded with goods expires on February 28. That means from March 1st, 2010, Maersk can ask for the container detention charge. Chanlian also made a promise through email on March 30 that the shipper would bear the container's detention charge, but Chanlian did not make any payment. On February 21, 2011, the goods were auctioned by Newport Customs in Mumbai, India. On February 28, the customs signed a bill of lading requesting Maersk to deliver the goods to the buyer. On February 27, 2012, Maersk filed a lawsuit in Guangdong province of China requesting Chanlian to be responsible for the container detention charge, which was calculated from March 1, 2010. This case went through 3 stages. The second instance court affirmed the first instance judgment, but the retrial court set aside the second instance judgment. Both of the first instance and the second instance courts held that this case is a dispute over a contract for the carriage of goods by sea. The limitation period for the action is 1 year, counting from the date on which an obligee knows or should have known that its rights have been infringed. The reason of the violation of Maersk's rights was that the containers provided by Maersk were occupied beyond the contracted period of time, and the damage continued uninterrupted until the goods were auctioned by the customs. Then, the damage caused by the detention of containers was suspended and the amount of fees was fixed. Therefore, the first instance court and the second instance court believed that the limitation period for Maersk to exercise the right of claim should be calculated from the date on which the goods delivery notification was issued by the Newport Customs, Mumbai, India. So the courts held that the limitation period lasted from February 28, 2011 to February 27, 2012. And Maersk filed a lawsuit in the first instance court on February 27, 2012, which did not exceed 1 year's limitation period. Because the containers were occupied over time, the shipper, that is Chanlian Company, should be liable for compensation. Therefore, the first instance court decided that Chanlian should compensate Maersk for the detention charge of the 5 containers involved of RMB 150,000. The second instance court affirmed the first instance judgment. China Company applied to the Supreme People's Court for retrial. In the view of the Supreme Court, after the goods were transported to the port of destination, Maersk had fulfilled its contractual obligation. But the 5 containers were occupied for a long time and unable to be put into normal turnover, thus constituting a breach of contract. Maersk has a right to request the compensation of extended use of the containers from the shipper. According to the relevant regulations of China, the limitation period for this kind of claim is 1 year, counting from the date on which Maersk knew or should have known that the rights had been infringed. According to the confirmation of all parties, the shipper, that is Chen Lian, should pay Maersk the container detention charge from March 1st, 2010. That is said, Maersk knew or should have known that its rights had been infringed since March 1st, 2010. Chen Lian made a promise through email on March 30 that the shipper would bear the container's detention charge, which constituted the suspension of limitation as stipulated in Article 267 of the Maritime Code of the People's Republic of China. Therefore, the limitation period of this case should be counted from March 30, 2010. Maersk filed a lawsuit on February 27, 2012, which had exceeded the 1-year limitation period and lost the right to win the case. So, the Supreme People's Court set aside judgments of first instance and second instance and rejected Maersk's claim of the action. With a slowdown in global trade growth, the shipping market has also experienced a continuous downturn, resulting in the emergence of a large number of maritime disputes. Among them, disputes over the fees for the extended use of containers have been rising in maritime cases in recent years. The standards of domestic judicial practice in China have not been unified, and the international treatment of such disputes is not the same, causing the relevant shipping companies at a loss of rules to follow in practice. Through the review and correction of this case, the Supreme People's Court has made a very clear determination of the nature of the dispute over the fees for the extended use of containers in the contract for the carriage of goods by sea.